In the matter of GEDDAM, JHANSI and other versus State of Telangana and others, Supreme Court allowed criminal appeals and stated no prima facie case has been made out against the appellants to continue with criminal proceedings against them, and allowing these to continue would amount to abuse of process of law. Premlata had filed a written complaint before the Mahila police station in which it was mentioned that she was married to Samuel Suresh, a doctor by profession and a resident of Chennai, and at the time of marriage, her mother-in-law Pathagadda had demanded a sum of 30 lakh rupees, and accordingly, the complainant's mother had given 10 lakhs by way of cash and 15 tolas of gold as dowry to her mother-in-law. It was stated that for about 5 months of marriage, the complainant's husband had treated her well and took care of her properly. Unfortunately, later her husband, suspecting her character, harassed her mentally and physically to get additional dowry of 10 lakhs, for which her mother-in-law, younger sister of her mother-in-law, her brother-in-law, and the son of Gaddam Jhansi, namely Gaddam Satyakama Jabli, pressurized her to act according to her husband's and mother-in-law's wishes, and also threatened to kill her if the demand for dowry was not met. It was also alleged that because of their behavior, the complainant's mother organized panchayat several times before the elders and other family members. It was alleged that in front of the elders, her husband had agreed to take care her properly, but as usual, after some time started harassing her, because of which she ultimately approached police for counseling, but there was no change in behavior, leaving her no alternative but to file the forced complaint. Another complaint was filed by a complainant alleging cruelty and criminal intimidation under Domestic Violence Act, making similar allegations with the additional allegation that on one occasion her husband asked her not to touch his clothes and to go away from the kitchen, and that he tried to burn his socks because the complainant had washed them. It was also alleged that her husband had influenced his friends to talk ill of her, who in turn used to call the complainant and ask her to leave her husband, further telling her that her husband has a girlfriend who had taken divorce to marry him. It was also alleged that on 17 October 2020 at around 10 p.m., the complainant was beaten and pushed out of the matrimonial house by her husband. Before the enforced complaints were filed by the complainant, the husband of the complainant introduced a divorce proceedings alleging neglect, insensitivity to the needs of the husband, incompatibility, concealment of facts, showing hostile attitude towards the husband, refusal to consummate the marriage, causing mental and physical harassment and desertion. Supreme Court said, when we minutely examine the statements of her father and mother of the complainant, what can be seen is that as far as demand for dowry of rupees 30 lakhs and giving of rupees 10 lakhs and 15 sovereigns of gold at the time of marriage of complainant is concerned, it can be said that it was within their direct knowledge. Being the father and mother, the complainant daughter would naturally convey to them what had transpired with her in relation to her husband and family. Thus, as regards other allegations of harassment, the same were informed to them by their daughter, but they were not witness to the same. It may also be noted that as regards the alleged act of beating of complainant by her husband, other relatives mentioned by parents, the complainant herself does not mention so in her complaints. Therefore, this allegation of beating of complainant is something that has been added by father and mother of the complainant, though they did not themselves witness the same. It is evident that there are certain specific allegations made against husband, his mother, about demands of dowry and harassment meted out to the complainant. However, as regards present appellants, the allegation against them is that they, along with other accused family members, used to pressurize complainant to act according to her husband and mother-in-law's wishes. Apart from this generalized allegations, there are no specific or overt acts attributed to the appellants which would tantamount to acts of cruelty or physical or mental harassment or being active participants in the demands of dowry. Invoking criminal process is a certain serious matter with penal consequences involving coercive measures which can be permitted only when specific acts which constitute offences punishable under the penal code or other penal statute are alleged or attributed to the accused and a prima facie case is made out. It applies with equal force when criminal laws are invoked in domestic disputes. Criminalizing domestic disputes without specific allegations and credible materials to support the same may have disastrous consequences for the institution of family, which is built on the premise of love, affection, cordiality, and mutual trust. Institution of family constitutes the core of human society. Domestic relationships, such as those between family members, are guided by deeply ingrained social values and cultural expectations. These relationships are often viewed as sacred, demanding a higher level of respect, commitment, emotional investment compared to other social or professional associations. For the aforesaid reason, preservation of family relationship has always been emphasized upon. Thus, when family relationships are sought to be brought Within the ambit of criminal proceedings, rupturing the family bond, courts should be circumspect and judicious and should allow invocation of criminal process only when there are specific allegations with supporting materials which clearly constitute criminal offences. We have to keep in mind that in context of matrimonial disputes, emotions run high, and as such, in the complaints filed alleging harassment, domestic violence, there may be tendency to implicate 18 other members of the family who do not come to the rescue of complainant or remain mute spectators to any alleged incident of harassment, which in our view cannot by itself constitute a criminal act without there being specific acts attributed to them. Further, when tempers run high and relationships turn bitter, there is also a propensity to exaggerate the allegations, which does not necessarily mean that domestic disputes should be given the color of criminality. It goes without saying that genuine cases of cruelty and violence in domestic sphere which do happen ought to be handled with utmost sensitivity. Domestic violence typically happens within the four walls of the house and not in the public gaze. Therefore, such violence is not noticed by public at large, except perhaps by immediate neighbors, thus providing visible evidence by the victim of domestic violence may not be easily forthcoming and producing direct evidence may be hard and arduous, which does not necessarily mean that domestic violence does not occur. In fact, to deal with this pernicious phenomena, stringent statutes like Protection from Domestic Violence Act 2005 have been enacted with expansive meaning and scope of what amounts to domestic violence. Since violence perpetrated within the domestic sphere by close relatives is now criminalized, entailing serious consequences on the perpetrators, the courts have to be careful while dealing with such cases by examining whether there are specific allegations with instances against the perpetrators and not generalized allegations. The purpose and mandate of the law to protect the victims of domestic violence is of paramount importance, and as such, a balance has to be struck by ensuring that while perpetrators are brought to book, all the family members or relatives are not indiscriminately brought within the criminal net in a sweeping manner. For a matrimonial relationship which is founded on the basis of cordiality and trust, to turn so to an extent to make a partner to hurl allegations of domestic violence and harassment against the other partner would normally not happen at the spur of a moment, and such acrimonious relationship would develop only in course of time. Accordingly, such a situation would be the culmination of a series of acts which turns otherwise an amicable relationship into a fractured one, thus in such cases involving allegations of domestic violence or harassment, there would normally be a series of offending acts, which would be required to spelled out by the complainant against the perpetrators in specific terms to rope such perpetrators in the criminal proceedings sought to be initiated against them. Thus, mere general allegation of harassment without pointing out the specifics against which such perpetrators would not suffice, as is the case with respect to present appellants. The court was thus of the view that in criminal cases relating to domestic violence, the complaints and charges should be specific as far as possible as against each and every member of the family who are accused of such offences and sought to be prosecuted, as otherwise it may amount to misuse of the stringent criminal process by indiscriminately dragging all members of the family. There may be situations where some of the family members or relatives may turn a blind eye to the violence or harassment perpetrated to the victim and may not extend any helping hand to the victim, which doesn't necessarily mean that they are also perpetrators of domestic violence, unless the circumstances clearly indicate their involvement and instigation, hence implicating all such relatives without making specific allegations and attributing offending acts to them and proceedings against them without prima facie evidence that they were complicit and had actively collaborated with the perpetrators of domestic violence would amount to the abuse of process of law. Our observations, however, should not be generalized, Supreme Court said, to mean that the relatives cannot be brought under the purview of the aforesaid penal provisions when they have actively participated in inflicting cruelty on the daughter in law of the victim. What needs to be assessed is whether such allegations are genuine with specific criminal role assigned to such members of the family, or whether it is merely a spillover and side effect of a matrimonial discord and allegations made by an emotionally disturbed person. Each and every case of domestic violence will thus depend on the peculiar facts obtained in each case.